He is in charge of the legal work for the largest public interest law firm in the United States, Steve Shapiro.
So thank you very much, Bruce. It is true I've had only one job in my life, and my 27-year-old son, who's a wise ass, describes me as vocationally challenged. But that's not really true. I'm just one of these incredibly fortunate people in life who stumbled into what was always my dream job as my first job, and I've never found a better job since, and I have felt very honored for all these years to be able to serve the ACLU. I was struck by Bruce's comment that he brought his first case, ACLU case, 40 years ago, and I thought to myself, Bruce, if you were an ACLU staff lawyer as opposed to an ACLU volunteer lawyer, the second half of that sentence would have been, and the case is still going. So I also want to extend my congratulations to the high school students and the program that was honored today. And nobody asked me to do this, but I think I can speak on behalf of all the adults in the room and say I'm delighted that I did not have to answer those questions. And it is actually hard for those of you who have been gone to law school and are lawyers. It's hard to stand at a podium like this and not feel like I should be either giving an exam or taking an exam, one or the other. I just did want to tell one other story before I talk about what I was asked to talk about tonight, but this is in honor of Ray. I told the story to Bruce and Martha the other night, but at times when it's easy to get discouraged because progress is not as fast as we might hope it would be, it's useful to remember that indeed there has been significant progress in our lifetime, and this country and this world is a very different place than it was even when I started to practice law. And the story comes out of a recent experience I had, which is I was invited to speak at a joint in Charleston, South Carolina, at a joint meeting of the North and South Carolina Women's Bar Association. That itself is a sign of progress. There were 800 women lawyers from North and South Carolina in the room, and that wouldn't have been true when I graduated from law school. But they were not there to hear me. They were there to hear the dinner speaker, and the dinner speaker was Sandra Day O'Connor. And she, instead of giving a talk after dinner, did one of these Oprah kind of things where a former law clerk of hers, who I happen to know, just asked her a series of questions. There was a conversation between the former law clerk and now the former Supreme Court justice, and they were sitting in easy chairs up on a dais in front of this banquet hall. And so the first question that she was asked was the following. The law clerk said, so we now have a new justice on the Supreme Court, Sonia Sotomayor. She's only the third woman justice in history. I was just wondering whether there were any stories from your own confirmation hearing that you would like to share. And then Sandra Day O'Connor proceeded to tell the following story, which I had never heard. She said that she was in Arizona in 1981 when she got a call from the White House, which she described as a complete shock. I'm not sure I believe that part of the story, but she said she got a call from the White House saying that the president wanted to nominate her to the Supreme Court to be the first woman justice on the Supreme Court, and would she accept the nomination? And she said, I was flabbergasted and felt unqualified for the job, but I didn't think that should stand in my way, so I said yes. And then she said, as you know, from reading the papers, if nothing else, the first thing that happens after you're nominated for the Supreme Court is they ask you to fly to Washington and go on this round of courtesy calls in the United States Senate. And she said, for me, the most important courtesy call was to Senator Strom Thurmond, who was the longtime senator from South Carolina, and the last Mrs. Strom Thurmond was in the audience when she was telling the story. And she said Strom Thurmond was the most important person for me to go see because he was at the time the chair of the Senate Judiciary Committee. So she said, my husband John and I went to see Senator Thurmond, and I thought to myself, well, that's an interesting sentence in and of itself, because I guarantee you, I don't know this, but I feel fairly confident saying that John Roberts did not bring his wife on his courtesy calls to the United States Senate, but she was the first woman nominee, and she brought her husband. And so she said, John and I went to Senator Thurmond's office, and he was incredibly gracious, and we walked into the office, and he welcomed us, and he was effusive, and he then ushered us into these two seats on one side of the desk, and he sat on the other side of the desk, and he looked at me and said, do you mind if I call the president? And she said, go ahead. And so he dials the White House, and he's Senator Thurmond, and so he gets Ronald Reagan on the phone. And she said, I'm only hearing one end of this conversation, but the end of the conversation I hear goes like this. Mr. President, this is Strom. I have this really wonderful lady in my office, and I understand that you've nominated her for the United States Supreme Court. And what I want to know is this just a symbol, or is this for real? Oh my God. And she said there was, a pause for about a minute, and then Senator Thurmond said, yes, sir, yes, sir. And then he said, so you actually want me to get her confirmed? She said there was another pause, and then she said, Senator Thurmond said, yes, sir, yes, sir. And then he hung up the phone, and she said he turned around to me all smiles and said, well, I guess we're going to get you confirmed. And true to his word, he got her confirmed. And I tell that story not only because I kind of like the story, but because it is a reminder, I think, of the enormous progress that has been made, and as I said, has been made in our lifetime. And it's relevant to the topic that I was asked to speak about tonight, which is progress or just promises, and lawyers always put colons after the first part of their titles. So what should come after the colon is the presidency of Barack Obama. And the answer to the question, progress or just promises, the presidency of Barack Obama, is not surprisingly a little bit of both. Any questions? No. And that's inevitable. One of the things about the ACLU, one of the wonderful things about the ACLU is we have the advantage of historic perspective. I was counting on my fingers, so this may not be exactly accurate earlier this evening, but I believe this is the case, that Barack Obama is the 16th person to serve as President of the United States during the history of the ACLU. So we have been through 16 presidencies. And if we have learned anything during those 16 presidencies, is that there are some administrations that are more sympathetic to civil liberties, there are some administrations that are less sympathetic to civil liberties, but the need for the ACLU never disappears. And I think that one of the things that happened with the election in 2008 is that many people were so overwhelmed by the historic significance of that election, and it's worth recalling the historic significance of that election because there have been things about the Obama administration that have been disappointing. There are things that have been very encouraging, but there are things that have been disappointing. But every once in a while, you just have to take a little step backwards and a deep breath and say, there is an African American who is President of the United States. And the truth is, I never thought I would see that in my lifetime. Right? I'm not sure I ever thought I would see a woman on the Supreme Court in my lifetime, but I certainly never thought I would see an African American as president in my lifetime. And one of the things that is so remarkable is not only that we have passed that historic milestone as a country, but that it is really not the subject of much discussion or debate in the country. Which is not to say that I don't think that some of the hostile response to the Obama administration is not tied to race. But I think to a remarkable extent, the country has absorbed and accepted the fact that there is a black man who is our national leader. And that is something to be incredibly proud of. Whatever else happens during the course of the Obama administration, right? We have lived through a moment in history, and it's a moment of history that should make us feel very good. Right? But having said that, Obama is not the Messiah. I think, there was this sense out there among many people we all know that if Obama were elected, all the problems of the world would be solved, and we would all live happily ever after. Right? That hasn't happened, and it was never going to happen. Right? On the other hand, I sometimes think that Obama has been saddled with unrealistic and unrealizable expectations. It was never realistic to ask a politician, and that is what Barack Obama is, to ask a politician to deliver on all the promises that people and all the hopes that people invested in him, right? Now, part of the reason that people invested hopes in Barack Obama is because he was so good at inspiring hope, right? But the record 13 months into his administration is a mixed one. And if you're really interested in a sort of detailed synopsis of Obama's record on civil liberties and civil rights, we prepared a year-end report card, which is a fairly lengthy document that appears on our website, and you can download that document. And it makes for very interesting reading, because what we did is we prepared for the Obama administration, as many other public interest organizations did, a transition document. And we said, in a whole range of areas, right, that are of concern to the ACLU and concern to all of you, we said, these are the things we think the Obama administration ought to be doing when it gets into office. And then we just went back over that list a year later, and we said how many of those things have been done and how many of those things have not been done, right? It's hard to give grades, right? Maybe it's a B. A B is not an A, but it's a lot better civil liberties and civil rights record than the past administration, right? And that's worth remembering. That's worth remembering too. And so, what I wanted to do is in the 10 or 15 minutes that I have left, and the arrangement agreement that I made with Bruce is that I would keep these remarks relatively short, and then we would open it up to discussion, so people could ask about anything they wanted to ask. It doesn't have to be related to the Obama administration's civil liberties record. But I thought it was worthwhile to begin with some of the positive things the Obama administration has done, because I think, again, part of the unfairness that the Obama administration has had is when they do a good thing, they don't sometimes get recognized for it because we expect them to do the right thing, and then when they disappoint us, we're very vocal in expressing our disappointment. So I think we ought to acknowledge and give credit for what they have done. And let me just start. I mean, obviously this is not a complete list on either side of the ledger, but let us not forget that in the first week in office, President Obama came into office, he signed 3 executive orders. The one that has gotten all the attention said I was going to close Guantanamo in a year. Whoops, didn't quite make it. That's unfortunate. But at least he put himself on record for expressing the desire and the intent to close Guantanamo. But the other 2 executive orders said I'm going to end torture, and I'm going to end the process of secret imprisonment in CIA black sites around the world. And as far as we know and as far as we can tell, he has done those 2 things. And that is significant. It's especially significant because if you read the paper this morning, you will see that the Justice Department just issued a report yesterday in which they didn't quite exonerate, that's not quite the right word, but they concluded after many, many years of internal debate that two Justice Department lawyers, John Yoo, who now teaches at the University of Berkeley School of Law, and Jay Bybee, who's now a judge on the United States Court of Appeals for the Ninth Circuit, and who were the principal authors of these so-called torture memos, right, had not engaged in professional misconduct by producing legal advice for the United States government saying that torture was lawful. Right? They said the report yesterday said the reasoning was flawed, but that the lawyers had not engaged in professional misconduct in endorsing that reasoning. Right? I agree with the first half. I don't necessarily agree with the second half. But for these purposes, what is important to remember is we had a Justice Department that for 8 years, we had an administration that was practicing torture and a Justice Department that was legally justifying torture. Right? We don't have that anymore. We don't have that anymore, and we ought to be thankful and grateful that we don't have that anymore. Right? We also have an administration that has at least gone on record as saying now, belatedly, took them a year to get there, and they're moving more slowly than I would like them to move, but they are now on record as supporting repeal of Don't Ask, Don't Tell. Right? And we had a really, really eloquent statement by the chairman of the Joint Chiefs of Staff, Admiral Mullen, in front of Congress, explaining why he no longer supported the policy of Don't Ask, Don't Tell. Now, I don't agree. What they've agreed to do is they've agreed to study for a year how to end it. I don't quite understand that. But nonetheless, we're moving in the right direction, and that's important. We have an Obama administration that has, in many critical respects, re-energized and rededicated poor sections of the Justice Department that were undermined and nearly destroyed during 8 years of the Bush administration, including most prominently for our purposes, the Civil Rights Division. The Civil Rights Division of the Justice Department became an anti-civil rights division under the Bush administration. It has become a civil rights division again under the Obama administration. And very good people have been put in charge of the Civil Rights Division, and we should be grateful for that. The Obama administration has changed its policy on immigration enforcement. There are a lot of problems I have with the way the Obama administration is continuing to enforce the immigration laws, including delegating enormous authority to local law enforcement around the country to enforce the immigration law in a way that has maybe inevitably, but certainly in fact, led to horrible racial profiling all over the country. Right? That's a problem. But the systematic practice of mass workplace raids that we saw under the Bush administration, we're not seeing under the Obama administration. That's progress too. It's not as far as we would want to go, but it's progress. And the Obama administration has introduced a level of transparency that didn't exist under the Bush administration. Again, they are not as transparent as I would like them to be in ways that I will talk about in just 1 second. But they are much more transparent than the government that we had for the 8 years prior. They have changed their policy on Freedom of Information Act requests, right? And they have changed their policy on classification of secret documents. In both cases, the changes are designed to produce more public information rather than less. And the change in the FOIA policy is highlighted by the decision of the Obama administration to release the reports of the Office of Legal Counsel that were then the subject of this Justice Department report yesterday, the memorandums by the Justice Department purporting to provide a legal justification for torture. We could not. Those documents were released in response to an ACLU lawsuit. We couldn't get those documents from the Bush administration. We got them from the Obama administration. There are other documents we still want from the Obama administration that they're not giving us, but they gave us more than the Bush administration was willing to give us. Right? And so all of those things are positive, and we ought to recognize them as positive. Right? On the other side of the ledger, however, there are some serious disappointments, and there are some serious ongoing discussions with the Obama administration that have not been resolved. While the Obama administration is more transparent than the Bush administration, it continues, for example, to assert and defend an extraordinarily broad definition of the state secrets privilege, which has been used by the was used by the Bush administration and is still being used by the Obama administration to defeat any serious judicial inquiry into the practice of extraordinary rendition, which is just, a fancy euphemism for kidnapping. Right? We represented. I don't have enough time to tell this whole story, so I'll just give you the punchline. But we represented a man named Khalid El-Mari, who was a German citizen who was the victim of this program of extraordinary rendition, was originally taken into detention in Macedonia, where he was vacationing. I don't know, but I suspect at the behest of the CIA. But then very shortly thereafter turned over to the CIA and brought and detained in a black site, which is to say an undisclosed location operated by the CIA in Kabul, Afghanistan. The government very, very early on in the story knew that they had the wrong person. They knew it was a case of mistaken identity, much like the Denver police. It's not just a problem with the Denver Police Department. CIA has mistaken identity cases too. And they held this man for the next 4 months because they just couldn't quite figure out how to let him go. Right? And the story is horrible in all of its details. But when he finally got out, he went to a German lawyer. The German lawyer came to us. We agreed to represent him. We filed a lawsuit in federal court in which we sued George Tenet, who was the director of the CIA, and several people under George Tenet. And the government did not come in and deny the allegations. They didn't come in and defend the allegations. What they did was they walked into court and they said, this case must be dismissed because if any of this occurred, which we will neither admit nor deny, it was part of a covert intelligence operation, and covert intelligence operations are by definition secret, and because they're secret, we can't talk about them in court, and since we can't talk about them in court, we can't defend ourselves, and if we can't defend ourselves, you must dismiss the lawsuit. Right? By the time this case got to court, there had been German parliamentary investigations by the Council of Europe, front-page stories in the New York Times and Washington Post, and various international journals around the world, all of which had investigated this man's story and largely corroborated it. And so the government came in and filed their motion to dismiss, and being the sophisticated lawyers that we are, we prepared a response which essentially said, in legalese, you got to be kidding. And we said, how can it be? How can it be that the whole world is talking about this? The whole world is talking about this, and the only place we can't talk about it is in the U.S. court of law? That can't possibly be right. And the case was dismissed a week later. I tell that not to relitigate the El-Mari story, but because the Obama administration is now defending the same broad assertion of the state secrets privilege that the Bush administration used in the El-Mari case. It's a different case, but involves the same set of issues. And it was actually very interesting because there was an argument scheduled in the case a week after the inauguration. And the Justice Department lawyer showed up in court in California. It was one of these precious moments. And the judge looked at him and said, do you have anything to tell me? Because he was fully expecting the Justice Department to come in and say it had changed their position. And the Justice Department lawyer said, no, Your Honor, we're continuing to defend the same position. And the lawyer said, you are? And he said yes. And so that is, a real disappointment. The government's response to the Christmas Day bombing has been disappointing in some ways. I think there are things that they're doing that need to be done. That guy should never have fallen through the cracks the way he did, right? But their response has been, part of their response has been, we need to put more people on watch lists. We don't need to put more people on watch lists. We need to have fewer people on watch lists. And we need to have a way to get the people who are mistakenly on the watch lists off the watch lists. And as one of my colleagues said very early on in the post-9/11 period, if you're looking for a needle in the haystack, the answer is not to put more hay on the haystack, right? And that's been the problem with the watch list all along, and it's another area in which the Obama administration is largely following the policies of the Bush administration. The Obama administration has been much more hesitant than I think they should have been to impose some level of accountability on people who committed serious human rights violations during the Bush administration. I think President Obama is fundamentally wrong in saying we need to turn the page and move on. We can't move on until we come to terms with what was done in our name. And this latest Justice Department report is another example, I think, of essentially wanting to move on and not look seriously at what was done in the past. But the two biggest issues that we are confronting and the two places where we are engaged in the biggest battle with the Obama administration both revolve around Guantanamo at this point. And one has to do with the issue of indefinite detention. When President Obama gave a speech last spring at the National Archives, he reaffirmed, again in ways that we would not have heard from President Bush and that were welcome, because words matter and rhetoric matters, reaffirmed the nation's commitment to the rule of law. But when he proceeded to then describe the roughly 200 people who are still being held at Guantanamo, he divided that group, he actually divided them into 5 categories, but for these purposes I will divide them into 3 categories. He said there are those people who we have decided are either never should have been held or in any event are no longer dangerous, and those people we will send home as soon as we can. There are those people who we want to try because they committed crimes. And we are going to try them, and we are going to try them in a court that satisfies due process. But then he said there is a third group of people. And that third group of people consists of Guantanamo detainees who are too dangerous to be released, but who, for one reason or another, we are unable to try. And we know that the primary reason why we are unable to try people who we otherwise think are too dangerous is because the evidence of their dangerousness was obtained through torture, right? And is therefore inadmissible in a regular court. But he said there is this category, and we are not going to release those people. Those people will be held indefinitely. We will provide them with some sort of due process, although what that is not clear because it's certainly not a trial. If it were a trial, they would have been in the other category. But that group of people is going to be subject to indefinite detention. We have never had in the history of the United States a system of preventive detention. And the notion that we would now go down that path and that we would hold people for what could be the rest of their lives without either charging them or trying them with a violation of law would be a tremendous step backwards for the United States, and something that no other Western democracy has felt obligated to do, even though we are hardly the only Western democracy that has been subject to terrorist attacks. And so Obama's endorsement of this notion of indefinite detention is extraordinarily troubling and extraordinarily fundamental. Okay? Beyond that, we are now in a very, very dicey moment around this issue of those people who the administration believes have in fact committed crimes and that can be charged and tried for those crimes. Because as you probably know, when Obama ran for office, the Bush administration's answer to that group of people is we will try them in military commissions. And we will try them in military commissions that were created only for the purposes of obtaining convictions at Guantanamo that resembled no court of law that we have ever seen in the United States and that had no credibility anywhere around the world. But that is where we will try them, said the Bush administration. Obama, as a campaigner, said those military commissions do not satisfy due process standards and do not honor our traditions of fairness and justice. And we will defend our values by being true to our values and giving those people who have committed horrible crimes against the United States a real trial, because we can do justice in this country, right? It's what distinguishes us from them. And then he got into office and he backtracked. And he said, yes, there are still some people we will try in federal criminal court. There are other people we will try in military commissions. I'm not going to eliminate the military commissions. I'm going to improve them. And in fact, he did improve them in some ways, but not enough. And then he took the category of people that the government thought they could charge and try and said, part of that group will be tried in military commissions, and another part of that group will be tried in what we would regard as a typical and traditional federal criminal proceeding. And among the group that they committed themselves to trying in federal criminal court were the 5 so-called high-value detainees being held in Guantanamo, led by Khalid Sheikh Mohammed, the self-proclaimed mastermind of 9/11. And against really tremendous opposition, the Obama administration, Eric Holder, Attorney General, announced that they were going to dismiss the military charges against Khalid Sheikh Mohammed and his co-defendants. They were going to indict them, they were going to bring them to New York, and they were going to try them in a federal criminal court. And we gave enormous support and praise to that decision by the president because it was the right thing to do. Now what is happening, of course, is the backlash has developed. You have officials in New York, my hometown, saying these people can't be tried here. A response I have to say I do not understand as a New Yorker, not as an ACLU person. I do not understand it as a New Yorker. I have precisely the opposite reaction as a New Yorker, that these people flew their planes into the World Trade Centers in my town, and that there is no more appropriate place to try them than in my town. Right? But that is not, once again, I find myself out of touch with America. That is not the prevailing reaction, and now all the politicians have lined up and said, not in my backyard. Lindsey Graham, senator from South Carolina, has introduced a bill that may get voted on next week that will prohibit the use of any federal funds for a criminal trial of these defendants in the United States. It's a very interesting constitutional question. If the students want to research this, that would be a great help. It's a very interesting constitutional question. And the administration is teetering. The administration is teetering. And one of the things that the administration needs to hear from people like us, and that's why I consciously began tonight by talking about the things that they did right. They need to hear not only criticism for us, they need to have our support when they're doing the right thing. Because the only voices they hear should not be the voices of people who say that our country is too weak or too incapable of providing true justice to people who have committed horrible crimes against us. Right? Precisely the opposite is true. Precisely the opposite is true. And so if you come out of tonight's meeting with any message, what I really urge everybody to do, and this decision is likely to be made in the next week or two, is let your representatives know, let your senators know that the answer to terrorism is not diluted justice. The answer to terrorism is to stand by the values that the terrorists have chosen to attack. We have, since 9/11, prosecuted, convicted, and imprisoned 150 people in our federal criminal court system. 3 people have been prosecuted and convicted in military commissions since 9/11, 2 of whom are now free. Right? It's not a better system. It's not a swifter system. It's not a juster system. And it's not the system we ought to be following. And so I feel like my report card on the Obama administration is incomplete at the moment. My disappointment will be profound if they reverse field and announced that they're going back to the military commissions. I hope that is not the case, but I believe that this is a defining moment for this administration. And I also believe, based upon the few sources I have, I also believe that this is an administration that, at least on this issue, and I think on many of our issues, actually wants to do the right thing. The problem is not a lack of conviction. The problem is a lack of political will. Because there are other people in Washington who are saying to them, these issues are not important enough to jeopardize other parts of your political agenda. There are only a few people out there who care about where we try terrorists. Right? And that may be true. That may be true. But there are more people than they think, number one. We just have to make sure they understand that. And number two, the entire history of the ACLU is premised on the notion, the history of the Bill of Rights, right? The purpose of the Bill of Rights is premised on the notion that there are certain enduring principles that do not depend upon the support of the majority, but were created precisely to safeguard the rights of the minority and often the rights of a despised minority. And this is one of those moments. And we'll see how the Obama administration responds. And, I will just end, but Dorothy Davidson, I'm sure, has heard this more often than I did, but I have been around long enough that when I first joined the ACLU, Roger Baldwin, who was the founder of the ACLU, was still around. He was no longer our executive director, but he was still around for the first 4 or 5 years that I was at the organization. And at that point, he was in his 90s. But he was still a very vibrant man, a very opinionated man, and an incredibly passionate and eloquent speaker. I heard him speak maybe 3 times before he died. And every time I heard him speak, he ended the same way. And he ended the same way, which was with a quote from Robert Louis Stevenson. And Roger would say, he had this great raspy voice at that point in his life, he would say, as Robert Louis Stevenson used to say, it is better to travel hopefully than to arrive. And he would say, at the age of 93, I am still traveling hopefully, and so is the ACLU. And the reason that that quote resonates so well is the ACLU is never going to arrive. We are never going to live in a perfect society where civil liberties and human rights are respected for all. Which means the good part of that is the ACLU is not going away. We will be here when you get out of law school. We will be here when your grandchildren get out of law school. But at the same time, it's really important that we travel hopefully. And so I thank all of you for coming out tonight, because I will say to you that for those of us who have the privilege of working for this organization, one of the things that keeps our hope alive is knowing that we have the support of people like you. So thank you very much for showing up today, and I think we have some time for questions. Allison, is Allison here? Is there a method to this madness? Or,
you want to just travel? Well, either come to the mic. Bob?
No, I can speak.
But can we all hear you?
Oh, I think you can.
I'll repeat the question. How's that? Okay.
Let's assume, which is the big assumption, that the quid pro quo, or part of the quid pro quo for health care reform in this country, was Obama's concession on military tribunals. How do you weigh those two issues, given the implications for the absence of health care reform in this country and civil liberties and rights of uninsured people in this country.
Well, look, these are obviously enormously. These are the judgments that politicians have to make all the time, right? And to be more precise, there you will hear people in the White House saying, we need support of Senator Graham, and we can't afford to antagonize Senator Graham over military commissions because we may need his support on health care or budget reduction, deficit reduction, or pick your favorite issue of the day. And while it is, not an ACLU issue, I will offer my own personal opinion. I think that health care reform is more than a priority. I think it's an absolute necessity for this country. It's a national shame, the health care system that we have in the United States. That being said, right, everybody's got to draw their line somewhere. And I think that there are certain issues of principle. I'm all for making deals. If you have to make deals. I understand that politics is the art of compromise, right? But there are certain principles that I think are not compromisable. And I think one of the principles that is not compromisable is that we cannot be either in a position of locking people up without charges or trial, or trying high-profile defendants in a trial that's going to be watched by the entire world in a proceeding that doesn't meet our standards of fairness and justice. I just don't think that's negotiable. So I think if the White House has to make its deals, it's going to have to find its deals elsewhere, would be my response to that question. Yeah.
Setting aside the argument of not in my backyard,
right,
which of course I don't agree with the September 11th defendants, do you think they could get a fair trial in New York City?
Let me put it this way: their lawyers think they can, right? Which is a more relevant question. One of the differences too. There are two questions, right? Military trials versus civilian trials, and if civilian trials, where should the civilian trials be? One of the many deficiencies of the military justice system as it has been rigged for these purposes is it doesn't provide the defense with nearly the resources it needs in order to adequately defend its clients if those trials are transferred into the federal court system, in large part because they are capital trials. The government is going to seek the death penalty, right? The defendants will have resources available to them that are not available to them in the military system, in addition to a system of rules and procedures that has been tested over time as opposed to one that has been made up ad hoc, right? Now, could they get a fair trial? I mean, can you find a jury of 12 that will be able to judge the case impartially? Look, it's going to be hard, but I don't know that it's going to be any harder in New York than it would be in Denver, frankly, because yes, the Trade Center was in New York, but this was very much an attack on the United States, and I think that most people in the United States treat it as an attack on the United States, and so I think those problems, to the extent that they exist anywhere. And I suspect in these cases, frankly, the real fight is not going to be, the big battle is going to be over the sentence, not over the conviction. Because, thus far, some of these defendants have been, willing to admit guilt in various forms, right, under various circumstances. Now, whether any of that is admissible and whether any of it is credible, and, all of that remains to be tested. But these trials will be difficult wherever they are. Yeah.
On a different topic, I was just wondering how the ACLU stands on the recent Citizens United versus FEC case.
Well, this is pretty good. It took to the third question before we got to campaign finance. I'm only pausing because it is there's a complicated answer, but I'll give you the simple answer. The simple answer is that the ACLU's position for 30 years has been that we are opposed to government regulation of political speech, regardless of the source of that speech, because we do not trust the government to make the judgment about who should speak and how much they should speak and when they should speak. Right? And that the solution that we prefer and have advocated for over the years is not government regulation, but public financing of political campaigns. on the theory that if we provided adequate funding for public financing of campaigns, you would reduce the demand to raise money from other sources, right? And disclosure. People should know where the money is coming from. We have supported both of those things. Having said that, I will say it is almost certainly the most controversial position that the ACLU takes with its own members, right? Most of our members understand Skokie. You know, that may be controversial to the rest of the world, but most of our members get that. This is very contentious among our membership and within our national board. And so over the last 3 decades, the national board has revisited this policy 4 times. And it is now in the midst of one of those reviews that began before the Supreme Court decision but happens to overlap with the Supreme Court decision. The board next meets in April. And I think it's very hard to know what the board will do. So it is conceivable to me that the board, as it has done 3 times previously, will ultimately decide the policy is the right policy. It's also conceivable to me the board could change that policy in some ways. But for the moment, we have been against regulation. The one other thing I will say about this is if you read, I mean, I've said this in other public places. I'll say it now. I've been more ambivalent about this policy than many other people in the ACLU leadership. I find it a closer question than others in the organization do. But the most powerful part of Justice Kennedy's opinion, to me, Justice Kennedy wrote the majority opinion in Citizens United. The most powerful part of the opinion is at the beginning, where he recites the system of regulations that has developed over the years to regulate campaign speech, right? To determine who can say when and who can say what and when they can say it. Right? And he says, and I think this is absolutely true, that the system of regulations has now become so complex that it is almost like the tax code. So that when people want to speak, including the ACLU, we don't take positions on candidates, but we speak out on issues. And under some versions of the law, we would have been limited in our ability to speak out on issues. That when organizations primarily want to engage in political speech around a campaign, and our campaigns go on for 12 months, people feel the need, we feel the need, to go to lawyers and say, this is what we want to say, can we say it? Right? And Justice Kennedy says any system of regulations that leads to that result, where people are so uncertain about what they can say about the political issues of the day that they need a lawyer's advice before they talk, ought to at least give us pause. And I agree with that. I think that ought to at least give us pause. So I think the issue is somewhat complicated, but I just got back from a conference in Europe that wasn't talking about these issues, but because the decision had just been decided, I was sitting having a conversation with somebody from Britain, a lawyer from Britain and a lawyer from France. And I said to the lawyer from Britain, I really envy they're going to have a parliamentary election in May, and their elections are 6 weeks long. And I said, I envy your 6-week elections. I wish we could figure out some constitutional way to have a 6-week campaign in the United States. Instead, what we have is, a 12-month campaign. And then I said to the French guy, I said, what's the rule in France? And he said, in France, we do not allow political advertising of any sort. You can put up a poster on the wall, but you cannot take out an ad in the newspaper. You cannot take out a radio ad. You cannot take out a television ad, whether you are the candidate or whether you are somebody who is supporting the candidate. We just don't allow it. And I thought that was interesting. But I say it just to say that these are both democracies. And so there are different ways to structure a democracy, but that kind of extreme response would be inconceivable in our country, given our First Amendment tradition, for better or for worse. So that's where we stand. The final thing I'll say about Citizens United is I think, whether you like it or don't like it, I think the apocalyptic response to it is overstated. I don't think it's going to produce this flood of corporate money into campaigns, or more of a flood than we already have. And there are many reasons for that, including the fact that I think most corporations, truth be told, do not want to engage in the practice of taking out ads that says, Exxon supports John McCain, Exxon supports Barack Obama, because the moment they take an explicit position like that, they risk alienating a large percentage of their customers. And why would they want to do that? And so I don't think we're going to see as much of what people fear as you've been reading in the press, but we'll find out soon enough, and I could be wrong. So, yeah.
What has the Obama administration been doing with the USA Patriot Act?
Supporting reauthorization of the USA Patriot Act.
In its full present form?
The USA Patriot Act is, yay big, right? And there were a series of provisions that were designed to expire, sunset, as we say, after a period of time, and that period of time is now running out. And so there are a half a dozen provisions that have to be reauthorized or they will lapse. And the Obama administration is urging Congress to reauthorize all of them. So is the answer to the debate.
ACLU's position on that?
We want them all to expire. Actually, it's not that. That's a little too flip. We want them all to expire in their current form. There are changes that could be made to some of them that might make some of those provisions, acceptable to us, but in their current form, they are not acceptable to us. Yeah.
Several years ago, I read in the paper that ACLU had initiated a lawsuit against Donald Rumsfeld. Mm-hmm. And what's going on with that now?
We are hanging on by a slender thread. Because, and this is another position that has continued from the Bush administration to the Obama administration. We brought, this is a reference to a lawsuit that we brought on behalf of a group of, I'm trying to remember the exact number, 4 Iraqis, 4 Afghanis, who had been tortured while in U.S. custody, military custody in Iraq and Afghanistan, and we sued Donald Rumsfeld and others for those acts of torture. And the position that both administrations have taken has been that, number one, we shouldn't even be allowed to bring those cases in a U.S. court because, without getting too much into the weeds, so one version of this is, to the extent that we were saying that torture violates the Constitution, which is certainly one thing we were saying, the Constitution does not apply in Iraq and Afghanistan, and therefore they have no constitutional rights that they can claim against the United States government. But then a secondary position is that even if the torture happened, and even if it was unconstitutional, it was not clear at the time, right, that it was unconstitutional. And because it was not clear at the time under a doctrine known as qualified immunity, Donald Rumsfeld should not be forced to pay damages for having done something that a court later decides is unconstitutional, but he couldn't have known was unconstitutional when he did it. But what's interesting is part of the sort of interesting legal fight, what they claim was unknown was not that torture was illegal. They say what was unknown was that the Constitution applied in Iraq and Afghanistan. And we say, even if that was not settled, right, that's not the issue. The issue is when you ordered somebody tortured, did you know it was wrong at the time? And of course you knew it was wrong at the time because it's been wrong as long as we've had law. So they've been moving to dismiss the case, and for various reasons, it's been slowed down because there are some other cases ahead of it in the pipeline. So we've lost at every stage, but we have one last appeal left, and we're waiting for a final decision, is the answer.
Is the ACLU working on warrantless surveillance, trying to stop it?
Yes, that's it.
My understanding is the Obama administration has just rubber-stamped everything with Bush's.
Not entirely true. 75% true. Bush enacted a system of warrantless surveillance, right, where he was not getting approval from the court, and he was acting in violation of a federal law that said he needed to get judicial approval, right? So he was thumbing his nose at both the courts and the Congress, right? In the waning days of the Bush administration, Congress passed a law that essentially authorized a system of broad surveillance without warrants as we have traditionally understood warrants, which means they didn't need an individualized warrant that said, I want to wiretap Mark Silverstein's phone. They were able to say, I want to wiretap the phones of everybody who lives in Denver, right? And that Congress said you can get that kind of warrant in a terrorism investigation. President Obama, after saying he was going to vote against that, he was in the Senate at the time, after saying he was going to vote against it, ultimately voted for it. The vote came up during the presidential campaign, and they have been living happily under that law since he was president. We sued the day the law was enacted. We lost in the trial court, again, not on the merits. One of the incredibly frustrating things of so much of this post-9/11 litigation has been the difficulty of getting courts even to reach the merits, because we keep, to the extent that we've won some, but to the extent that we lose, we tend to lose on procedural issues. So the grounds on which our surveillance lawsuit was thrown out was on the following logic. You cannot challenge a surveillance program unless you know that you have been the victim of that surveillance, and you cannot know if you have been the victim of that surveillance in this context, because these are national security wiretaps and the target of the wiretaps are secret. And since we won't tell you, and therefore you don't know, you don't have any right to sue us. And so it's an impossible catch-22, but we were in fact dismissed on those grounds in the trial court, and we now have an appeal pending in the federal appeals court in New York on that issue. Yeah.
All right, so jumping back to the Khalik Sheikh Mohammed issue,
okay.
It seems to me that although a trial in civilian court is necessary, that even with my short 17-year-old frame of reference, that this is not going to be anything more than a hanging trial. So how does the ACLU prevent the show trial from happening and actually giving these people a fair trial where there's the possibility that they're not guilty?
No, I don't agree with that, actually. I don't think it will be a show trial. I think it will be a trial that will follow a set of rules that we have come to accept as fair in our society, and his defense will be given the resources they need to mount the defense. That doesn't mean that at the end of the day, he and his co-defendants will not be convicted. Over 90% of people who are tried in court are convicted. But the fact that the conviction rate is very high doesn't mean that the process is necessarily unfair. And so I think he will get a fair trial. There are some difficult issues that will have to be worked out in these cases about access to information and various other things. But you know, we tried the people who bombed the World Trade Center the first time. Right? We convicted them. We sent them to prison. They're going to spend the rest of their lives in prison. There was no serious question about the fairness of that trial, and I think no serious outcry in the rest of the world about the fairness of that trial. People accepted the fairness of the trial, and they accepted the verdict. And I think, by and large, the same thing would happen this time. And I don't think it will happen in the military commissions, even the new and improved version of the military commissions, for two reasons. One is they're new and improved, but they're still not great. And secondly, the whole concept of military commissions is completely tainted. And it's completely tainted because it was created just for this purpose. It was not a system that otherwise existed. It was a system created for the sole purpose of getting convictions. And it's a system that, under the law that authorizes the military commissions, is only available to try aliens. It's not available to try citizens. And so, regardless of the fairness of it, what it looks like to the rest of the world is we've created a separate system of justice to try Muslims. You know, it's a doomed enterprise from the outset. And we should just put these people in criminal court, give them the trial, and if we have the evidence, we ought to convict them. And with the other people, I actually am very skeptical that there are many people out there in detention who are too dangerous to be released and yet who we cannot try. But if there is a category of people, there's a big debate about whether it's a theoretical category or a null set. But if there's an actual category of people, and if the reason that we can't try them is because we tortured them or tortured other people to give us evidence that incriminated them, I think we have to release them as well. That we just cannot be in the position of creating a second-class system of justice to make up for our own mistake in torturing people in the first place. I mean, it's a classic two wrongs do not make a right. And so, that's where we are, and we'll see where we wind up. And I think we're coming to the end of our session, and so thank you all again for coming up.